Today, we're going to have a look at the section of the study design called The People and the Australian Constitution. Although most people don't look at the Constitution, it is an incredibly important document. I hope each of you has downloaded a copy of it, not because you have to read the whole thing, or at least not that you have to understand the whole thing, but because you will understand better the sections you've looked at if you see them in the context of the whole document. So if you haven't downloaded a copy of it, please do so. You can go and buy a paper copy if you want, but you can download it for nothing on a variety of websites. It's important, the Constitution is important because it establishes Australia's parliamentary system. Now, as the next slide will show you, prior to Federation in 1901, Australia was a collection of separate colonies. This somewhat disconnected map illustrates what it was like. Each of these sections of Australia, as we now call it, was a separate colony of the British Crown. They became colonies at different times. New South Wales, as you probably know, in 1788, Queensland in 1824, Tasmania the following year in 1825, Western Australia in 1827, and South Australia and Victoria in 1834. As a result of Federation in 1901, the Commonwealth had a constitution and each state had a constitution. Now, this could have created real problems, but in order to make the federal system work, the Commonwealth Constitution sets out the division of powers between the Commonwealth and the states, as this next slide will show you. At the very top, you'll find that we have exclusive powers of the Commonwealth. Now, those exclusive powers are few and far between, but they cover things like defence and immigration and those sorts of issues that it was seen as absolutely essential that only the Commonwealth should have power to make laws about. In the middle, you find those that are concurrent. Now, both of these, the exclusive and the concurrent, are known as specific because they're actually written into the Constitution. Now, in fact, those concurrent powers can be exercised by both the Commonwealth and the states. But Section 109 of the Constitution, as you've probably already discovered, states that if there is a clash between those two laws, that is, concurrent laws, say a law made by the Commonwealth and a law made by the states on the same topic, Section 109 gives priority to the law made by the Commonwealth. So the Commonwealth law will prevail and the state law would fade away. At the bottom of the pyramid there, you have residual powers. Now, these aren't specific because they're not mentioned in the Constitution. These are residual powers, the powers that at Federation remained with the states, such as criminal law. So let's have a quick look at it again. Exclusive, not many. Things like defence and immigration. Concurrent, the example I've used there is taxation. States can impose taxes, so too can the Commonwealth. And residual powers can only be exercised by the states. And the criminal law, by and large, is the province of the individual states. Now, the Constitution, apart from the division of powers, also sets out the structure of the Commonwealth Parliament, as the next slide will show you. Now, here we have an illustration of the Parliament of Australia, the way it is structured. There is the Queen, who is represented, of course, by the Governor-General. And this is all specified in the Constitution itself. So we have the Queen, whose powers are exercised by the Governor-General. We have the Senate, which is the upper house of the Parliament. And we have the House of Representatives. And collectively, they make up the Parliament of Australia. The House, if we go backwards along that line from the House of Representatives, most laws start in the House of Reps, then proceed to the Senate, and then proceed to the Governor-General, where they receive royal assent. That is the Crown's assent to the law, and at that point, the law becomes a law. This model is replicated in Victoria, as the next slide will show you, where the model is repeated. The governor on the bottom right-hand corner, the Legislative Assembly, the Green House, which follows the colours of the Parliament in Westminster in England, and on the left side there, the Upper House. And so if we follow that same procedure, it doesn't always go in that direction. Sometimes bills can start in the Upper House and then go to the Lower House, but normally they'll start in the Assembly, go to the Upper House, the Legislative Council, and then to the Governor, who will sign them into law on behalf of the Queen. Now, what the Constitution also guarantees is the separation of powers. Now, if we move on to this slide, the Constitution divides power into three component parts. It separates power to the Parliament, that is, the elected representatives of the people, the executive government, and these are the ministers, the ministry appointed to manage particular government departments, and thirdly, the judiciary. And this model is followed in the states as well as the Commonwealth. People are elected to the Parliament, some of whom become the executive, that is, the government is formed, and those ministers then put the law into action. It's then, if a matter is brought to the courts, it's then for the courts to determine how those laws will be applied, and in some cases, whether those laws are even constitutional. Now, please do not confuse those two terms. Do not confuse division of power with separation of powers. Make sure you make your notes really clearly so that you don't make that mistake of confusing those two terms. Separation of powers is about the separation of power between the Parliament, the executive, and the judiciary. Whereas the division of power is which parliaments can make which laws. So try to make sure that you have that clearly set out in your notes. Now, what about the Constitution? What about change? The Constitution can only be changed by the vote of the people. There's a current proposal for a referendum to give Indigenous people a voice to Parliament. In other words, to include reference to that voice of Indigenous people in the Constitution itself. Now, you may already be aware, you probably are already aware, that there have only been 44 attempts to alter the Constitution pardon me, since Federation. But only 8 of those attempts to change the Constitution have actually been passed. And to be fair, only one of those was truly significant. That was in 1967. And that's explained in the handout that that I've provided for you, that your teachers will have printed off for you, or will have made accessible on a screen for you to have a look at. On rare occasions, so that's one way in which the Constitution, well, that is the only way in which the Constitution can be changed, by the voice of the people. That is a vote of the whole country. And in order for it to be successful, a referendum must be carried by the majority of states, that's 4 of the 6 states, and a majority of people across the whole of the country. Now, the territories are not counted in the majority of states, but the people in the territories are counted in the majority of the people, in the vote of the majority of people. Now, there is one other element to have a look at. On rare occasions, the states have voluntarily surrendered power to the Commonwealth. States can give up power that they may have had since Federation. They may give up that power to the Commonwealth. That's allowed under Section 51, Part 37. Very, very rarely used. States are not inclined to give up power. In 1986, states agreed that the family court, as it was then called, could deal with cases involving children of de facto relationships. Because up until then, the Commonwealth could only deal with disputes regarding custody of children and associated matters where the parents were actually married. Those children of unmarried parents, they could only be determined, or their futures could only be determined by the states. And it was felt that that was really rather silly for the whole of Australia for that breakdown to continue to exist. So in 1986, the states got together and they agreed to give up power to the Commonwealth. So all children of relationships, of parental relationships, maybe, and all children are, aren't they, of parental relationships, all children, their custody and other matters can be determined by one court and one court alone. In 2004, the states gave up property control over de facto relationships. And so those are two quite significant but rare examples of where states have voluntarily surrendered to give up power. Now, the Constitution also established the High Court of Australia. Aside from hearing appeals from the superior state and federal courts, it has the authority to interpret the Constitution. And this is a really, really important role. And it is set out, of course, in the Constitution itself. Now, you may have had a look at some cases in this area over the course of this unit, and I'm going to mention just 3 of them at this stage. The first one and these are all set out in the handout with which you've been provided. Excuse me. The first one in 1926 called Victoria against the Commonwealth. And it's also better known perhaps as the Rhodes case. And it deals with section 96 of the Constitution. And section 96 says that the Commonwealth has the authority to grant funds to states for whatever reason the Commonwealth sees fit. Now, Victoria and the Commonwealth in 1926 reached an agreement that the Commonwealth would provide some money to the state of Victoria to build a road, a new road. Victoria said, "Thank you very much, Commonwealth, we'll have the money." But then they decided that they'd build a road somewhere else, not where they'd come to the agreement with the Commonwealth to build it. And the Commonwealth said, no, 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 you can't do that. Now, it's not a good idea to stand between a state premier and a bucket of money. But this time, the Commonwealth came off best. Victoria took the Commonwealth to the High Court, but the High Court said, "I'm sorry, Victoria, section 96 is perfectly clear. The Commonwealth can grant money to states on whatever reason and whatever grounds it thinks fit." And so, Victoria, if you want to build the road, you've got to build it where the Commonwealth says. You can guess what happened. The Commonwealth gave the money and Victoria built it where the Commonwealth said. Now, if we march forward to 1982, we come across the case of Kuata and Bjelke-Petersen. Now, this is a very, very important case in relation to Indigenous land rights. Under section 5129 of the Constitution, the Commonwealth has the power to enter into foreign affairs. In other words, it can sign treaties with other countries. Now, one of the treaties that it signed was an agreement against all forms of racial discrimination. Now, I won't go into the gory details of the case, but Bjelke-Petersen, the Premier of Queensland, offered land to people who wanted to develop industries. Kuata, an Indigenous man, wanted to develop an industry together with some of his Indigenous colleagues. Bjelke-Petersen said, "Oh, we'll give money to anybody, but not to Indigenous people." And so Kuata took the matter to court. The High Court ruled in Kuata's favour. Third case I want to mention, as I said, these are all set out in the handout, is Australian Capital Television against the Commonwealth. And this was in 1992. The Commonwealth had passed legislation to ban advertising in the lead up to elections. Now, Australian Capital Television decided that this wasn't a really good idea. And they said that under section 7 and 24 of the Constitution, people have to vote at elections. How on earth can they vote at elections if they don't know what the issues are? And so Australian Capital Television took the Commonwealth to the High Court, and the High Court ruled in favour of Australian Capital Television and ended the ban on advertising elections because it would have prevented people from knowing appropriately the main issues that were relevant to the forthcoming elections. Now, in the handout, there's a series of cases leading up to Liberty Works in 2021. In relation to that case, teachers may like to have a look at the article in the most recent edition of the Monash Law Review, Monash University Law Review, in which Justice Geoffrey Nettle discusses the future of the implied freedom of political communication. Now, that can be read online. If you simply Google Monash Law Review, latest edition, you can find that article there, and teachers may like to have a good look at that in order to pass on the current state that was established initially in Australian capital television and the Commonwealth and has undergone a bit of a battering in the years since, leading up to Liberty Works in 2021. There are also excellent resources on the Victoria Law Foundation's website on the Constitution. So for teachers and for students, have a look at those sections of the website because there's quite a bit of information there that will be of use to you. Well, I hope this brief talk has helped you understand the importance of the Constitution, and I can't overstate it. I wish you all well for the remainder of the year in legal studies and the best of luck in your final examination. Thank you for being with me.